My lady, with your ladyship's leave, aware as I am that I'm going more slowly than intended, I'm hoping to reallocate, if I may, a quarter of an hour or 20 minutes of my reply and put it into my submissions from now onwards, so that I will finish at quarter.
It's a matter of indifference to us how you divide up your time, but your time is your time, and that's it.
Metal and Rohstoff, which is bundle 5, AB 5, divider 51, MS 2077 is the head note. M&R were a Swiss company which traded in the London markets, the London Metal Exchange. They were defrauded by a company called AML, and AML didn't prove to be worth pursuing, although they were successfully pursued. And so an action was commenced against their parent companies in America for inducing AML to break its contracts with, in a fraudulent manner with M&R, as a result of which AML withheld certain metal warrants which were held by AML, and they refused to return them to M&R. The question of this, as I say, was the first case after the new rule came in, and
Excuse me, I'm just asking if the security man can shut the court's door. Thank you.
Sorry, no,
I'm sorry, I interrupted you. He wasn't understanding my gestures, and so...
If I can take your ladyship to page 2134. The at letter D on 2134, the acts of inducement which are alleged against the defendants led to trading contract breaches took place in New York. And then at letter F, it seems clear, and M&R plead, that AML's first breaches of contract occurred in New York, and Asona, on behalf of M&R, were told that AML would not pay the ledger credit due to M&R and would retain the M&R's metal warrants. They were the ones that were held in London. These were plain repudiations, and M&R did not accept them. There were then further breaches. And he then deals, it's Lord Justice Slade, the judgment of the court, the top of the next page, 2135. The damage, says Lord Justice Slade, which M&R suffered as a result of the trading contract breaches was, in our view, suffered in London. M&R did not receive the ledger credit payment, did not receive the warrants, and suffered the detrimental closing out of their accounts in London. And sorry, I've lost the reference. Sorry, if I could go back to 2122, which is the construction of the rule. 2122.
436.
436 and 437. And there, Lord Justice Slade deals with the change in the rule. Until 1987, leave could only be given, this is the top of 437, if the action begun by writ and so on. The rule was changed to give effect to the Brussels Convention on Jurisdiction and the decision of the European Court of Justice in Bière. As the rule now stands, it's plain that jurisdiction may be assumed only where, and he deals with it in an unconventional manner. That was all I wanted to take from Metal and Rohstoff, which is in 1987. Paragraph D, my friend wants, might have to claim another 30 seconds.
D
no
on
authority
page...
was cited to support the suggestion. Sorry? 437D.
Yeah.
No authority was cited to support the suggestion that this is the correct construction of the convention to which the rule gives effect, and it could lead to an absurd result if there were no one place in which all the plaintiff's damage had been suffered. So I think I've probably... it's enough if some significant damage had been sustained in England. So that was the argument. Sorry, I didn't really appreciate it. The argument was that when it said the damage was sustained in England, the defence was saying all the damage had to be sustained in England. There were, in fact, some metal warrants which were held in Belgium, and so the defence said, because not all the damage was sustained in London, there was no jurisdiction. And this is the court's answer to that, that the damage, the significant damage, was sustained in London and not in Belgium, and so jurisdiction was granted. So that preceded the development of the European jurisprudence, which the next step of which was in the case of Dumez, which is in the Authorities Bundle 9, 97, at 3401. And I can go straight to 3403. This is the judgment of the court. And at 3403, paragraph 3, Dumez and Off sought compensation for the damage which they claimed to have suffered owing to the insolvency of their subsidiaries established in the Federal Republic of Germany, which was brought about by the suspension of a property development project in the Federal Republic for a German prime contractor, allegedly because of the cancellation by German banks of the loans. Over the page, by a judgment, the tribunal in Paris upheld the objection of lack of jurisdiction raised by the German banks on the ground that the initial damage was suffered by the subsidiaries of Dumez and Off in the Federal Republic, and that the French parent company sustained a financial loss thereafter only indirectly. At the bottom of 3404, the question is the rule on jurisdiction, which allows the plaintiff under Article 5.3 to choose between the court of the place of the event and the court of the place where the damage occurs, to be extended to cases in which the damage alleged is merely the consequence of the harm suffered by persons who were the immediate victims of damage occurring at a different place. So just interpolating there, that is the situation we submit, which applies in a fatal case, although this was, of course, a pure economic case. At 3405, at the bottom, paragraph 12, it must first be stated that the judgment in Mine de Potasse related to a situation in which the damage to crops occurred at some distance from the event, giving rise to the damage, the discharge of the saline waste by an undertaking established in France, but by the direct effect of the causal agent, namely the saline waste, which had moved physically from one place to another. By contrast, in the present case, the damage allegedly suffered by Dumez through cancellation by the German banks of the loans granted for financing originated and produced its direct consequence in the same member state, namely the one in which the lending banks, the prime contractor and the subsidiaries which were responsible for the building work were all established. The harm alleged by the parent companies is merely the indirect consequence of the financial losses initially suffered by their subsidiaries following cancellation. It follows that in a case such as this, the damage alleged is no more than the indirect consequence of the harm initially suffered by other legal persons who were the direct victims of damage which occurred at a place different from that where the indirect victim has subsequently suffered harm.
And I can see the logic of that in relation to knock-on effects on somebody other than the person who, in the first instance, suffered the damage. But what do you say is the test, in principle, for distinguishing between direct and indirect damage? And I'm not asking you how you apply the test to particular facts, such as those in this case. What is, can you state a test which applies?
I'm not sure I would attempt to state a test which applied to the full range of torts which can be of enormous breadth and complexity. But I would submit, in personal injury, obviously, Your Lordship knows my submission. In cases of financial loss, it's where the immediate loss arises as a result of the tortious conduct, rather than the consequential loss which may occur in a different bank account. The case of Marinari is perhaps indicative there of what the difference is, but perhaps one would hide behind the answer that recognising direct as opposed to indirect loss, or immediate or as opposed to consequential loss, is something you can recognise, but it's
just the elephant test, is it?
I'm sorry, my Lord?
It's just the elephant test.
The elephant test. I think that's the best I can do for the moment. But it's certainly the initial damage which gives rise to a cause of action. In a personal injury case, again, that is simple, because the initial damage is the initial injury to the person, and that is a single cause of action. It may be more complicated in a fraudulent misrepresentation claim where damage occurs in different locations as a direct result of that fraudulent misrepresentation. So if, for instance, you are persuaded by fraud to invest in a housing estate in Spain and in Portugal, then it may well be that you have damage, direct damage suffered at the place where you make those direct investments as a result of the fraud, but not at the place where those bad investments are felt back at head office in London, as your Lordship said, and on the bottom line.
Dumez was harm suffered by somebody else as a result of harm suffered by the immediate victim.
Yes.
So we need to get on to something closer to this case, don't we?
Well, that is close to this case in terms of fatal claim, because here, in a fatal claim, the consequential financial loss is suffered as a result of the infliction of injury and death upon...
All Fatal Accident Act claims are indirect in their entirety. I find this...
Yes.
This concept rather difficult.
Well, that is
it at least is the assumption behind these rules that there is some direct loss which you have to distinguish from the indirect loss. The concept of a tort which gives rise to only loss that you categorize as indirect, thereby effectively making the damage suffered wing of the jurisdiction clause irrelevant in such cases. I do find that rather strange.
Well, there is loss in a fatal claim. There is damage suffered by victim one, which is a precondition.
Yeah, but he's not the one with the claim under the Fatal Accident Act.
No, just as in Dumez, the one with the claim for the loss of value in his subsidiary was not the one who was actually damaged by the decision of the German bank. Marinari was, again, a case, that's in bundle 10, tab 102, 3458. This was a case of a man who was domiciled in Italy at 3458, who had lodged promissory notes with the Manchester branch of a bank whose registered office was in London. The bank staff, taking the view that the notes were of dubious origin, contacted the police. Plaintiff was arrested and the notes sequestrated. After his release, the plaintiff brought an action in Italy, seeking payment by the bank of a sum representing the exchange value of the promissory notes and also compensation for the damage he claimed to have suffered as a result of his arrest, including damage to his reputation. The bank objected to that, and on a reference held at the bottom of that page, while the term place where the harmful event occurred in the meaning of Article 5.3 could cover both the place where the damage occurred and the place of the event giving rise to it, could not be construed so extensively as to encompass any place where the adverse consequences of an event that had already caused actual damage elsewhere could be felt. It did not include the place where the victim claimed to have suffered financial loss consequential on initial damage arising and suffered by him in another contracting state. And at MS 3470, again taking it very shortly if I may, the court said at paragraph 14, whilst it's thus recognised that the term within the meaning of Article 5.3 may cover both the place where the damage occurred and the place of the event giving rise to it, that term cannot be construed so extensively as to encompass any place where the adverse consequences of an event that has already caused actual damage elsewhere can be felt. Consequently, the victim, as in the present case, the victim claims to have suffered financial damage consequential on initial damage arising and suffered by him in another contracting state. So perhaps in answer to your Lordship's question as to the definition, it is that if there has been damage which can be seen to be the immediate damage, perhaps in terms of time or in terms of location close to the source of the tort, such as to establish a tortious liability, that thereafter the way the damage develops is consequential. So those are the authorities that interposed in Europe. The next case I want to look at was the Eris Isle actions, which is bundle 7 of the authorities at tab 68. And it's page 2628. It's a very short passage. At 2647. This is the Court of Appeal in England, Lord Justice Mustill, and he's dealing with a claim relating to disastrous insurance contracts. At 2647 in the left-hand column, he deals with jurisdiction under Order 11. In the next paragraph, the addition of a reference to damage sustained within the jurisdiction is comparatively recent and is intended to give effect to Article 5, it should be 3, of the Brussels Convention on Jurisdiction, as interpreted in Beer and Mine de Potas. They then deal with, at page 2648, Metal and Rostoff is sufficient to dispose of any possible argument to the effect that since Clarksons may well have suffered damage abroad, in addition to any which they suffered within the jurisdiction, the paragraph could not apply. He then deals with the case of Beer, and over the page at 2649, Lord Justice Mustill, in the left-hand column, looks at the Ruffer case, although he gets the Advocate General's name wrong at the top there. But he says, after the summary of the case, he says, the reasoning of the Advocate General is, in our respectful submission, unanswerable, could properly have been applied to the present case if Clarksons, that's the claimants, had been basing their claim solely on the situs of the head office of their group. But they can say more than this, for the damage of which they complained is their exposure to claims by SCORE and the other plaintiffs. These are being pursued in England. If successful, will result in judgments in the English court enforceable against Clarksons in England. We consider that in a real sense that amounts to the suffering of damage in England. So again, it's an elephant that they've recognised there as being damage within the meaning. There is a very useful authority, but I won't take your lordships to it, at Bundle 1, tab 8, called Bastoni. It's a decision of Mr. Justice Ricks, which also analyses the case, we say, quite correctly. But I would like to go in Bundle 1 to ABCI and BFT, Bundle 1, which is the first tab of Bundle 1, MS 576. You will see that at the bottom of the left-hand column, ABCI alleged that by reason of fraudulent misrepresentations, they suffered fraudulent misrepresentations, claimed that they were concealed and not known, and couldn't have been found until September 1988. They applied to claim sovereign immunity. SDP applied to challenge the jurisdiction on the grounds that ABCI's claim did not fall within, and it should be Order 11, Rule 11F, there being no relevant act or damage within the jurisdiction. And at 590 of this bundle, again, the Court of Appeal, Lord Justice Mance, at 590, left-hand column, paragraph 41, about halfway through that paragraph, he says Order 11 was formulated as it stood in 1995 in order to be consistent with and give effect to Article 1111F. Sorry, in order to be consistent and give effect to Article 5.3. The fact that the present case is not within the scope of the Brussels Convention is by the way. The significance was considered in the light of authorities in the European Court of Justice by Mr. Justice Ricks in Domicrest. I should just mention that the word "the" after Metal and Rostoff was omitted by amendment to the rule, so that it became "damage was sustained" rather than "the damage was sustained," because your lordships will remember that it was argued that the damage meant all the damage. That was rejected, and so damage was substituted for the damage. At paragraph 42 on page 590, he then deals with the head under 1111F. ABCI committed itself to investing here. They arranged payment here or from here, and so on. Mr. Milligan submitted at paragraph 43 that an acceptance here of a prior purported acceptance here would constitute in domestic law the date when the claimant suffered sufficient loss to acquire a cause of action. But the Court of Appeal, in this case in an earlier format, held in the fraud action that this domestic rule is not imported into the concept of damage sustained under 11 Rule 11F. Again, this reasoning is underpinned by the consideration that although the present is not in fact a European case, subparagraph F was introduced in 87 in order to ensure that English law was consistent with Article 5.3 of the Brussels Convention.
Mr. Palmer, I think you said that the Brussels Convention has no forum conveniens.
That's right.
Doctrine.
Yes.
So this hard application of Article 5.3 to our interpretation of our practice direction, I mean, is there some conceptual difficulty about that? Because our scheme is perhaps to have a wider basic ground for taking jurisdiction and then cutting it away on forum conveniens. Well, so if you look at our scheme overall and then you apply the Brussels Convention, one part of our scheme being totally absent therefrom, is that problematical?
With respect, no. First of all, we widened our scheme to bring it into line with the Brussels Convention. So we were widening the scope of jurisdiction. That's fine. We can, having widened it, we can, in a non-European context, then apply forum non-conveniens. But the fact that we can apply that is no justification for saying that our widening in 1987 should now be motorway-size widening. It shouldn't. It should be the same. And second answer, which I'll come to in a minute, is that you're not comparing like with like. Forum non-conveniens is not looking at the same features as jurisdiction is looking at. And thirdly, I would say that the Scots have in fact done exactly that. They have actually got a rule that Article 5.3 applies in terms for jurisdiction, but you can apply a forum conveniens test as well. So there's no problem, and it's a fallacy in my respectful submission, as adopted in some of these first instance decisions, to take that as a rationale for having a different interpretation. I just ought to look at paragraph 43 where I was, where Lord Justice Mant says, just before the end of paragraph 43, the proposition that the appellants could be regarded as having sustained damage within clause F, both in the place where they purported to make or hold a board meeting, ratifying the share subscription, and in the place where they made their investment, allegedly under it, is less easy to digest. In our judgment, clause F is looking to the direct damage, sounding in monetary terms, which the wrongful act produced upon the claimant, see Dumez and Mr. Justice Ricks in Domicrest. So the rationale of direct damage is expressly adopted there by the Court of Appeal in 2003. That then brings me to the line of authority, which is dealt with in our case in an annex at the back of the case, which I respectfully refer the court to. It starts at page 42 of our case, page 146 of the MS, and those 6 or so cases are set out there. We set out one within that, which is a non-personal injury case, Mr. Justice Steele in Newsat. We commend Mr. Justice Steele's approach to the court and contend that the Court of Appeal is quite right to effectively overrule these cases as far as personal injury damage was concerned. We say that the first instance decisions suffer from the following flaws. Firstly, they fail to recognise that the wording in 1987 was a significant widening of what was there before. Secondly, that the intention to align the meaning with 5.3 was not properly taken into account, even though Court of Appeal authority showed repeatedly that it should be. The cases of RS Isle and ABCI were not taken into account. Metal and Rostoff was to some extent misunderstood, and the history of the rule did not appear to be clear to the courts. The decisions which were made by those first instance judges failed to recognise that their decisions ignored or destroyed the necessity for a significant connecting factor between the defendant and his or her activities and the cause of action in tort and the jurisdiction of the English court. And that is what those gateways are all about, is finding such a significant connecting factor and then applying it. And if you allow an accident which takes place abroad and causes immediate damage, then to be sued for in this country, you are making the cause of action entirely portable for the claimant to sue in his or her own domicile. And therefore, those decisions fail to appreciate the enormous width of the rule as interpreted by them and as criticised particularly pungently by the Court of Appeal in Erster, which is quoted in the judgment of Lady Justice Arden at paragraph 80 of her judgment at MS 253. And what we say about trying to control the gateway by reference to the concept of forum conveniens suffers, we say, from the following defects. And I think this is my Lord Hughes's question from before lunch, as well as my Lord Wilson's question just now. The gateway is statutory and it has certainty. It's enforced in the same way in equivalent situations because it's a matter of law how it should be enforced. It is therefore predictable. If wrong, the understanding is wrongly appreciated by the court as to what the gateway means, that's appealable as a question of law. The gateway is also different in kind from the forum conveniens control mechanism. The gateway is the statutory thing that gives the court power to take jurisdiction. Forum conveniens is a rule which enables the court, if it has that statutory power, to control how the power should be exercised. It relates to the exercise of power, not the existence of power. It also considers different things, not the connection between the defendant and the jurisdiction, which justifies bringing him in, but it considers the questions relating to all parties as to where would be the appropriate place for a trial. And finally, on forum conveniens, you lose predictability because the decisions are effectively discretionary, they're not appealable, and the same situations could give rise to different decisions, making it difficult for parties to know whether and to what extent a jurisdiction will be actually exercised by a court in this country. Please look also at what we say in our case at 92, paragraph 92 to 94, MS 133 to 134, relating to a question which my Lord Sumption asked earlier, where I say that the courts have decided that a cause of action for personal injury arises once and for all, unlike possibly a series of causes of action for a fraudulent misstatement, and therefore damage is sustained at the moment, as it were, of impact. Dealing with the Fatal Accident Act point, can I take your lordships to Lazar, which is Authorities Bundle 10. At 101, tab 101, 3436. The importance of this is its result, which is that under Rome 2, an accident which causes a death is an accident where the damage occurs in the place of the accident, not at the place where dependents are residing. The claimant was a Romanian resident who brought a claim against the defendants for compensation for damage sustained as a result of the death of his daughter in a road accident which had occurred in Italy. And it was held at the bottom of 3436, where it was possible to identify the occurrence of direct damage, as was usually the case with a road traffic accident. The place where the direct damage had occurred was the relevant connecting factor for the determination of the applicable law, regardless of the indirect consequences of that accident. That the applicable law determined who was entitled to claim damages and who was entitled to compensation. It covered in particular whether a person other than the direct victim could claim compensation by ricochet for psychological or financial harm. So the very fact of Rome 2 means that you apply the law of the place of the accident to determine whether there is a claim for loss of dependency. So therefore he decided the claimant's direct damage that occurred in Italy and the damage sustained by the close relatives was the indirect consequence of the accident within the meaning.
Is it a claim for dependency or for some kind of emotional?
All claims. The psychological loss grief or bereavement or anything of that sort. And the importance of the Advocate General's opinion, which I could just refer the court to, is at page 3445. At paragraphs 45 to 49, he aligns the wording and intention of Rome II as to where damage occurs with that which is in Article 5.3 of the Convention. So at the top of page 3446, paragraph 52, I consider that although the objectives pursued by each of the legal acts, that's Rome II and the Brussels regulation, are somewhat different, the concepts referred to in the Rome II regulation must, as far as possible, be understood by reference to the interpretations adopted in connection with the Brussels Convention or regulation. A degree of parallelism must be established in the interpretation of these notions, so far as the legal instruments all pursue an objective of the foreseeability of the solutions adopted. My lady, I won't take you to the judgments. They start at 3452, and particularly paragraph 25 and 30 at 3456 and 3457. So, my lady, those are our submissions.
Are they to the same effect as the Advocate General?
The result is the same without the full adoption of that reasoning.
Correct.
Those are my submissions on all but one matter, which my learned friend Miss Kinslow is going to take up. I haven't dealt with comparative jurisprudence. I point to the Scottish law, which, as I've said, is to adopt 5.3 in its entirety, but to overlay upon it the concept of forum conveniens. And in Canada, there are two cases which are of importance. Muscat, which is at Authorities 6, tab 53, which has been overturned to some extent by Club Resorts and Van Breda, which also merits reading at Bundle 3, tab 21. I shall sit down, with your ladyship's leave.
Yes, Ms. Kinsler. How long do you propose to be?
Well, my lady, I think I have 5 minutes of our allotted time, so, or perhaps 10 minutes. So perhaps I could give your ladyship and your lordships just some bullet points on this last remaining issue. The issue is, can the claimant discharge the burden of establishing reasonable prospects of success with respect to the fatal claim? And our case is that on the pleadings and evidence, she cannot do so. If I can just summarise our reasons, there are 3 reasons.
Sorry,
First,
I beg your pardon, would you just say that again?
Certainly. So the issue is, can the claimant discharge the burden of establishing reasonable prospects of success with respect to the fatal claim? And our case is that on the pleadings and the evidence before the court, she cannot do so. Our case is set out in paragraphs 96 to 122 of our written case. And in summary, we have 3 reasons for saying that the claimant fails to discharge the burden of proof. First of all, the applicable law is not English law. Secondly, the claim is brought only on the basis of the Fatal Accidents Act. And thirdly, the claimant cannot rely on foreign law, as it is not pleaded and there is no evidence before the court of foreign law. So taking each of those points briefly in turn, it's common ground that Rome II does determine the applicable law in this case. The fact that the accident occurred in Egypt is irrelevant for that matter. It's an EU regulation, but it applies in the English courts, including in respect of an accident in Egypt. And following the Court of Justice's decision in Lazar, as Mr. Palmer referred to, it is clear that for the purposes of EU law, the relevant damage for determining the applicable law is the direct damage sustained by the deceased in Egypt. The court has determined specifically that in a fatal claim that is the relevant direct damage. And so it is not arguable under Article 4.1 of Rome II that the applicable law is English law. And so the Court of Appeal were wrong to hold the opposite. Obviously, Lazar came after the Court of Appeal's decision, but it is clear that that is incorrect. My lady, Mr. Palmer looked at Rome II very briefly, but there are two exceptions under Article 4. There's Article 4.2, which has no application in this case because it depends on common habitual residence, so both parties would have to be resident in England for it to apply. And there's Article 4.3, which is an escape clause and would allow the court to apply English law if it was manifestly more closely connected, the tort, to England. Now, in our submission, there's no scope for arguing Article 4.3 in this case, and indeed, it has not been argued by the claimant. My lady, I refer the court simply to the Trevor Preparatoire on Rome II. I would take the court to it. It's tab 9, volume 9, tab 92, MS 3276. And the relevant passage is at 3286 and 3297. If I could perhaps just refer relationship to that briefly. (992) MS 3276 is the start of the Commission's proposal for Rome II. And the relevant passage is at 3286. At the time of the proposal, the relevant article was Article 3, which became Article 4. And the court will see that under paragraph 1, general rule, it stated that Article 3.1, now 4.1, takes as the basic rule the law of the place where the direct damage arises or is likely to arise. And I just draw that to the court's attention. I won't take you through it. But turning over to the next page, the Commission deals with the exception under paragraph 3, which becomes paragraph 4.3. That's MS 3287. And looking at what became Article 4.3, the Commission says, like Article 4.5 of the Rome Convention, paragraph 3 is a general exception clause which aims to bring a degree of flexibility, enabling the court to adapt the rigid rule to an individual case so as to apply the law that reflects the centre of gravity of the situation. And in our submission, the centre of gravity of this tort, which is the wording of Article 4.3, is clearly Egypt. And just at the end of the next paragraph, the court will see that the Commission says to make clear that the exception clause really must be exceptional, paragraph 3 requires the obligation to be manifestly more closely connected with another country. So it's clear that it only operates in exceptional cases. And in our submission to apply 4.3, in this case, where the only circumstance connected to England is that the claimant is resident here, would effectively be to subvert the rule in Article 4.1, because Article 4.1 focuses on direct damage. It excludes expressly indirect consequences. And so if the only relevant circumstance which can be brought into Article 4.3 is the fact that the claimant is resident here, that would be to subvert the rule. And in our submission, that is impermissible. And as a result, it is not arguable that English law applies. And it is certainly the case that there is no serious issue that the applicable law is English law, and that is sufficient. Moving on then to the fact that the claim is brought only on the basis of the Fatal Accidents Act, I give the court the references, but I won't take the court to the documents in view of the time. The claim form refers to damages under the Fatal Accidents Act. That's in the core bundle MS 305. There's no reference to any other cause of action.
Sorry, what was the reference?
MS 305.
305, thank you.
And the details of the claim are at 307, subparagraph 3. Mr. Donovan's witness statement in support, which is at MS 311, exhibits the draft particulars of claim and states at MS 318, paragraph 28J, that it's likely that English law will apply. There's no mention of the possibility of, expressly, of the possibility of Egyptian law applying. The draft particulars of claim are at MS 330, or perhaps just the full particulars of claim as served are at 364. At page 363, paragraph 3, reference is made to the Fatal Accidents Act, and the prayer at 373 is for damages under the Fatal Accidents Act. So the only claim pleaded is under the Fatal Accidents Act, and obviously, as a matter of English law, there is no other available cause of action for fatal accidents. There's no common law action for fatal accidents. It is only the statute.
If your appeal on the contractual point was to fail and the contractual claim was to proceed, Article 4, which is dealing with non-contractual obligations, would not apply. Would the claimant be able to hitch her dependency, head of damages, to her contractual claim?
Well, my lord, it was held by Mr. Justice Tugendhat that the law applicable to the contractual claim is not English law, and that was not appealed. So the contractual claim, if it proceeds, is not an English law claim. And so we would say that the Fatal Accidents Act, whether it could apply in an English contractual claim might be a matter for some argument, but it certainly couldn't apply in a foreign breach of contract claim. And so the court is in the same position. It has no evidence about foreign law for a cause of action in contract, as it were, whether that would give rise to dependency damages or not. And that's a finding of Mr. Justice Tugendhat, which was not appealed.
If Lord Wilson's hypothesis were correct, are you submitting that on the footing that in the absence of an appeal on the contract proper law, we assume that it is Egyptian law, and that in itself knocks out the fatal accident claim, Fatal Accident Act not being part of Egyptian law?
My lord, that is what I'm submitting.
On the basis of Cox and Ergo?
On the basis of Cox and Ergo, and on the basis that the presumption, if we call it that, or a default rule, would not assist the claimant because the Fatal Accidents Act simply does not apply.
Fatal Accidents Act doesn't. But the Fatal Accidents Act was only necessary, wasn't it, because the common law didn't recognise a dependency claim,
Absolutely.
Whereas quite a lot of other laws do.
Quite a lot of other laws do, but not all other laws, my lord. And what is clear from the case law, I'll give the court the references, it's clear that the court should not extract from a statute, the gist of a statute, and assume that there is a universal principle.
No, I'm not suggesting for a moment that you can read the principle behind the statute into the law of Mauritius or Egypt or anywhere else, but there may well be a dependency claim in Egyptian law, mayn't there?
There may be, but in the absence of any pleading or proof before the court cannot assume that.
No, I see that.
Foreign law is a matter of fact, obviously, in the English court, and the court can only proceed on the facts before it. As a matter of pleading, it needs to be pleaded, and as a matter of evidence, it can only be proved, or it is usually proved by expert evidence, and there is no pleading and no evidence before the court as to the content of any foreign law. There is a footnote, I think, in Malana Fran's written case before this court referring to Egyptian and Canadian law, but in our submission that is wholly inadequate, and it would not be a proper basis on which the court to proceed to rule. Just very conscious of the time, my lady, the Fatal Accidents Act, we say post Cox and Ergo, a decision of this court cannot apply to an accident abroad where English law is not the applicable law. and it is not arguable in this case that English law applies. So there's no serious issue to be tried on that or on the applicable law. No other English cause of action, so it would only be if there is a cause of action in foreign law, and that has to be pleaded and proved. The claimant seeks to rely on the presumption. That has, as the court will be aware, long been the subject of criticism, and in the case law, it is clear there has always been exceptions to the application of the presumption, and the recent trend has been not to apply it in cases where it is artificial or unrealistic. And in our submission, the presumption does not assist in this case because we know the Fatal Accidents Act does not apply unless English law applies. So simply translating the Fatal Accidents Act over does not assist the claimant. And in any event, it is inappropriate to apply it. My lady, if I could just perhaps take the court very briefly to Dicey, and then I'll give the court the references to Professor Fenterman's book. So Dicey is at tab 10, volume 10, tab 113. MS 3559. The rule is set out, Rule 25, in any case to which foreign law applies, that law must be pleaded and proved as a fact to the satisfaction of the judge by expert evidence. In the absence of satisfactory evidence of foreign law, the court will apply English law to such a case. And the footnote to that comment is, for qualifications to the absolute form of the rule, see further. And I'll take the court to further. But just at 9002, foreign law is a fact, the principle that in English court, foreign law is a matter of fact has long been well established. It must be pleaded and it must be proved. And a few lines down, it is also said to follow that if the parties elect not to prove the content of foreign law, a case will be decided by the application of English domestic law, as though the case were a wholly domestic one. And this is generally true. But in recent years, there have been increasing signs that this cannot invariably follow. And in cases where it would be wholly artificial to apply rules of English law to an issue governed by foreign law, a court may simply regard a party who has pleaded but who has failed to prove foreign law with sufficient specificity, as will allow an English court simply to apply it, as having failed to establish his case without regard to the corresponding principle of English domestic law. And then just the start of 9003, foreign law must be pleaded. The general rule is that if a party wishes to rely on a foreign law, he must plead it in the same way as any other fact. And then the first line of 9004, foreign law must be proved. English courts take judicial notice of the law of England and of notorious facts, but not of foreign law. Consequently, foreign law must be proved. And then if I can invite the court's attention to paragraph 9013, page 3564. It is now well settled that foreign law must in general be proved by expert evidence. Foreign law cannot be proved merely by putting the text of a foreign enactment before the court, nor merely by citing foreign decisions or books of authority. And then the last passage is at 9025, which is MS 3573. The burden of proving foreign law lies on the party who bases his claim or defence on it. If that party adduces no evidence or insufficient evidence, the court applies English law. This principle is sometimes expressed in the form that foreign law is presumed to be the same, but this mode of expression has given rise to uneasiness in certain cases. Thus, in one case, the court refused to apply the presumption where the foreign law was not based on the common law, and in others it has been doubted whether the court was entitled to presume that the foreign law was the same as the statute law of the forum. In view of these difficulties, it's best to abandon the terminology of presumption and simply to say that where foreign law is not proved, the court applies English law. Even so, there will still be cases in which the application of English law will just be too strained or artificial to be appropriate. However, although recent authorities demonstrate there are cases in which neither the presumption nor the default will be suitable for the disposition of the case, they do not yet offer precise guidance as to when this point will be reached. And then 9027, the recent practice of the courts suggests that the default application of English law where foreign law is not proved is not unqualified and is more likely to be challenged where the rule of English law is statutory rather than being a rule of common law. In principle, an English statute may not be applied to a matter governed by foreign law in circumstances where that foreign law has not been proved. if the English statutory rule appears to state a rule of purely domestic law or whether wording would need to be adapted or changed. The proposition that the gist of a statute may be extracted from its precise wording and applied to a case which is not governed by English law, but for which the content has not been proved on the basis that it states a rule of general application is dubious and probably wrong. And then 9029 over the page, MS 3575. The conclusion is there are cases in which the default application of a rule of English law is simply too problematic to be appropriate, but that apart from the fact that a court should not invent a rule of English law to be applied, no sharp line exists to define the limits. And then the last section of 930, however, as has been shown, it may be that the true principle is broader than the limited exceptions, and that in cases where it would be wholly artificial to apply rules of English law to a claim governed by foreign law, a court may simply regard a party who has pleaded but failed to prove foreign law as having failed to establish his case. And those propositions are taken up and elaborated on by Professor Fentiman, the expert on this, this aspect. Just the references, my lady, it's tab 10, 108,
Volume 10, do you mean?
Volume 10, tab 118, MS 3599.
You're now between you half an hour over your allotted time.
I'm about to sit down.
Which is half an hour off your reply time.
I'm about to sit down. I'll perhaps just summarise. There was two cases I was going to take the court to, but I can't. Shaker and Belhaj. I would particularly draw the court's attention to Belhaj. The Court of Appeal judgment is at Volume 2, Tab 9, 881, upholding the decision of Mr. Justice Simon, which is in the additional materials bundle at 5, Tab 5, MS 3742. And in that case, the Court of Appeal holds that a claimant who pleads English law in circumstances where it is not arguable that English law applies, it is simply artificial and inappropriate for the court to proceed on the basis of a presumption. So just by way of summary, the Fatal Accidents Act does not apply in this case. The default rule does not assist, because you would have to alter the Fatal Accidents Act to allow it to apply, and it is inappropriate to allow the claimant to rely on it in the context of a jurisdiction application, where the claimant bears the burden of satisfying the court that she has a claim with reasonable prospects of success, when it is clear that the claim that she's pleaded will fail as a matter of law, and she has pleaded no foreign cause of action. And in my submission, it would defeat the purpose of the merits requirement for the court to proceed on a fiction that foreign law is the same as English law. Those are my submissions.
Thank you very much indeed, Ms. Kinsler. Thank you.
Lady, my lords, we've provided fairly full written submissions in this case. We stand by, notwithstanding the submissions today advanced by the other side, we stand by those. This is a case where it is accepted by the defendant that England is the most appropriate forum in which to try this claimant's claim. And we consider that to be a material factor in the overall consideration of this case. Certainly the academic articles to which we can refer and will refer endorse that approach. The defendant's approach to the jurisdictional test, as elaborated on in the Canada Trust case, now known as the Canada Trust gloss, is, we respectfully submit, somewhat dated now, and that is no longer the appropriate test. It deviated in our submission from the Secon-Sa test. It is a gloss on that case, and later cases and the academic writings suggest that the Canada Trust gloss either is not correct or is not helpful in this context. What the test should be is a good, arguable case test. This court knows full well its powers and the circumstances in which and grounds upon which appellate court could intervene. With decisions below, we are not going to take up time dealing with those. We simply invite the court's attention, if we might, to the case of trust risk, which is in volume 7 at tab 37, Court of Appeal decision, Lord Justice Beatson and Lord Justice Christopher Clark.
Sorry, A7, did you say?
7,
Yeah,
volume 7, tab 73.
73, I thought it says 37, 73.
Page, MS page.
It's 3756, 2756 is the MS number, my lady.
Thank you.
Lord Justice Beatson, grounds for interfering with decision below, paragraphs 29 to 43. I'm going to invite your attention, however, if I may, respectfully. With paragraph 34. This is an appeal against jurisdictional findings, in which the court should show less circumspection than in forum convenience cases. Paragraph 34, where the sole issue is the construction of the contract, or as here the totality of the contractual arrangements, views may differ about the interpretation of contractual terms, but the construction of a contract is not a matter on which there can be more than one right answer. What we respectfully submit in relation to the issues below is Mr. Justice Tugendhat had to reach a binary decision. Yes, the contract was made in England, or no, it was not. Yes, the claimant had secured the right defendant, or it had not.
Say that's the same as construction of the contract, is it?
Well, it's indicating that...
It may be binary, I understand that.
Yes. Well, if I go on to paragraph 72 with Lord Justice Clark, Christopher Clark, I agree that in a case such as...
72, did you say?
72, Lord. While a degree of circumspection on the part of an appeal court is called for, the court should be less restrained than it would be in other cases. The characteristics of the case to which I refer are A, that the point in issue has only one right answer, B, that the question is one of construction of a written agreement, the making of which is not an issue. That was the fact. C, there is no significant dispute about the background facts. There was none here because the defendant produced no evidence whatever. And D, that if the English court is held to have jurisdiction, that question will not be looked at again.
Yes, but what's said against you see, Mr. Ross, is that it isn't a binary question. It's a question of whether you've passed the threshold.
Yes, and the question is, what is that threshold? Is it the Canada Trust gloss or not, which I need to come on to. This court knows that we were not called upon by the Court of Appeal to address either of these contract issues. The court there being fully satisfied that Mr. Justice Tugendhat was right in the identification of the errors in the master's judgment and reasoning, and that Mr. Justice Tugendhat had reached a correct decision on this issue. Further, the Court of Appeal in essence endorsed Mr. Justice Tugendhat's finding that the defendant was determined that the claimant should not find out which Four Seasons company had a management, licensing and advisory contract with the Cairo Hotel. And that being the hotel at which the concierge worked. Your Lordships, the court will find my lady MS 275, paragraph 64.
Of the judge.
Yes.
Yep.
MS 276, paragraph 74. Paragraph 130
I think he's on Miss Justice Tugendhat.
on MS 290.
The MS number.
Well, 74 is his reasons for paying no attention to the evidence.
Yes.
Mr. Newman and Mr. McManus.
Yes. And 130, my lady. Having started at 128, 129, dealing with VTB, and 131. Court of Appeal, paragraph 57, MS 248. It also has a resonance with that which this court had to deal with, in particular my Lord Clerk, in the case of Abella, if I pronounce that correctly, which is at tab 2 of volume 1, where my Lord Clerk endorsed what the judge below, Mr. Justice Lewison, as he then was, said was a case of technical game playing. I won't take the court to it, but there's a case called Malhuboy, which is in the bundles at
Are you taking us
Richard
to it? Are you
Malhuboy.
taking us to it, or are you not taking us?
I'm just going to mention paragraph 70, where that judge said a party who declines to reveal
Page?
2422 in the MS bundle. Thus, Ms. Sleeman indicated there might be relevant witnesses who are resident in Dubai, etc., unable to say what issues the evidence might go to. Similarly, she pointed to facts of various agreements obtained from Mr. Muslim by the claimants were governed by Dubai law, etc. However, she was unable, in the absence of any indication of what the defence would be, to identify any issues arising under these agreements which might need to be decided in this action. It is, I suppose, possible that there may be issues in due course about the amount of the sale of the proceeds, etc., etc. However, when the defendant is not troubled to adduce evidence to this effect, I see no reason to speculate about how this in his favour, and even if it is the case, the action needs to be looked at as a whole.
You take us to that for what reason?
To indicate that this is a similar case. It's an
Absence of evidence.
Absence of evidence.
They've got to put up with the consequences.
Yes.
What issue was this deputy judge deciding when he wrote those two paragraphs?
I think it was a jurisdiction case, wasn't it?
It was a jurisdiction
Yes, he's
case.
described. If you turned back to the previous page, I may have got it wrong. It rather looks as if he's just deciding the forum convenience issue. Was he?
Well, it looks at paragraph 72 as if that was so, if you look at the opening words of 72.
There's a heading, look, at the top of above paragraph 64. Now, is the test for forum convenience the same as the test for whether the gateway has been passed through, or is it different?
Well, if anything, it's more stringent.
Is it?
Yes.
I see.
But the difficulty about that is that suppose that you're right about this, and suppose that accordingly the action proceeds, you will then find that you are faced with presumably a rather greater volume of evidence, and if it turns out that it was not this defendant
Yes, my Lord.
Who operated the hotel,
Yes, my Lord.
you will simply have ended up hitting the buffers at a later and more expensive stage of the proceedings.
No, my Lord.
Right.
Because what this would be, it'd be one of those cases where there is a misnomer. In other words, we have identified the company and the activities which that responsible company were carrying out, namely its management of the hotel in Cairo, the Four Seasons Hotel in Cairo.
And when you say you've identified them...
In the pleading.
What?
In the pleading, my Lord.
I see.
Yes. And so it's like, if I draw an analogy, it's those instances where you say, you bring a claim against my landlord, but you've misdescribed the landlord and you've called it Company X, when in fact it's Company Y.
So what happens? You apply for an
You
order
apply
substituting a different party?
No, you apply to correct the name of the existing party. And so there are no limitation
But
issues.
it's not a misnomer if they're completely different companies.
Well, it is, because you're describing the claim against you as being one which you're bringing against your landlord, for example. Yes. Here it's against the company that is managing the hotel and which offers to its guests the tours.
Well, there's surely a difference between a case where you have misnamed the company and a case where you have simply sued the wrong company, not having any reason, as it turns out, for believing that that company had anything to do with the management. I don't see that this can be a misnomer case at all.
Well, if we go to
a different party?
No, well, my lord. We've described. If we go to the pleading, you can see the way in which we.
If you were entitled to treat this as a misnomer case,
yes,
it would follow that you could change the name of the company on the title to the action as a misnomer without serving any other company, and simply proceed on the footing that the company that you have sued was the manager, notwithstanding any amount of evidence that it was not.
Well, my lord, the same problem arises in our respectful submission where you have sued Company X as being your landlord when, in fact, it's Company Y. And you'd have the same issue, presumably there'd be an order that having got the correction, you would serve...
There's a difference between a case where you've got the name of somebody wrong
yes.
and a case where you've got the somebody wrong because you've sued somebody else. I mean, you've sued somebody who, on some basis that you may be in a position to enlighten us about, you have identified out of the various Four Seasons entities as being the operator of the hotel. Now, you can't simply treat that as a claim against the operator of the hotel, whoever it may turn out to be. If they're different corporate entities, the correct corporate entity has got to be served with the writ. You can't take all the characteristics of a different corporate entity whom you haven't sued and simply say, well, we meant to sue that person.
Well, what you're not doing is, if you have said, I'm intending to sue the person who owns or operates the hotel which offered this tour via its brochure, and you have named that company as Four Seasons X, and it turns out to be Four Seasons Y, because you've understandably been unable to ascertain that it's Four Seasons Y instead of X.
Your problem is... Sorry, go on, please.
Then it is a true misnomer case, because you've identified although you've got the name wrong, you've identified which company you're seeking to sue.
What you've done is you've pleaded as characteristics of the defendant company something that is in fact characteristics of a different company, and that being an essential feature of your case. On that hypothesis, you would fail at trial.
I have a suspicion that there's quite a lot of law on this, and that you're not sufficiently put off by my Lord's suggestion to say, right, we will throw our hand in now. You propose to proceed with the arguments on the issues that are actually before the court. Shall we do that?
Because there is a linkage between the two, as I'll come to indicate, if I may. At base, this is a factually very simple case, because we have a contract for an excursion with the concierge.
Well, it would be if you could find out who you're supposed to sue.
Yeah, it's not for want of trying. We actually asked the question specifically, my lord.
Well, I understand that. It's fair comment that you've met with a certain amount of obfuscation, to say the least. But on the other hand, you seem to have known at the time you started your action about the existence of a company that owned the hotel in Cairo.
It owned the building.
Well, yes, all right, I understand the point.
But that's not what you said in your pleading. You
Yes,
didn't say in your pleading that the second defendant owns the building. What you said was that they owned the hotel and were liable. I mean, owning the building wouldn't have made them liable for a car crash arranged by the business that happened to occupy the hotel.
Yes.
Your pleading only makes sense on the footing that you were alleging that they were the operators.
Well, no, because there's, as your lordship will know from other cases, ownership of a hotel doesn't necessarily mean that you're the one who's managing or operating it.
No, absolutely. But you can't possibly in your pleading have meant to assert that the second defendant was merely the owner of the land, because qua owner of the land, there couldn't be any basis on which the concierge, any sensible basis on which the concierge would bind you to the agreement.
Well, at this stage, your lordships will appreciate time limit is running. We have to make a decision as to who we're going to sue. You were going to spread the net wider rather than narrower, whilst in the time that you've got available between issuing your claim and having to serve your claim, you're endeavouring to ensure that you can ascertain some further information.
Well, you're clearly not obliged to explain to us, if you don't want to, why you've chosen not to attempt to get leave to serve that company. But having started the action against it, I'm bound to say personally, I'm a little puzzled why you haven't. You don't have to explain that if you don't want to, but it might help.
Litigating in Egypt.
No, you don't have to litigate in Egypt.
No, if
These proceedings are an effort to litigate in England against the defendant or defendants, aren't they? So, all right, well...
Well, we have no evidence that that company owns, operates the hotel.
Well, then why sue it in the first place?
Well, because we didn't know it at that stage.
All right.
That's
it.
Can you throw any light on a question which I asked your opponent and which he understandably felt unable to answer? How did you light upon the first defendant as a potential person potentially liable?
Yes, I can do that. It requires a number of steps, which I was going to take them to. We have to look at the holiday company cases, which serve to assist us in dealing with stage one, which is you approach this from the perspective of the reasonable claimant. What did the reasonable claimant believe was the party with whom she was contracting? And that party, it's not an issue in this case. Mr. Justice Tugendhat made that finding, that she acted reasonable in believing that it was a Four Seasons, an international company known as Four Seasons, which operated hotels internationally.
Yes.
When that is supported by the brochure that we have, the brochure uses Four Seasons tree logo. It also describes it on the brochure. I'll take your lordship to it if needs be. Identifies it as Four Seasons Hotel. Then the concierge is offering this brochure against a backdrop, which is it's within the hotel. It's only being offered to Four Seasons guests. And the hotel, according to the evidence of Mr. Labette, which is in the Appendix 2 bundle, is indicating that there is a plethora of these Four Seasons logos all over the hotel, and they choose to call themselves Four Seasons Hotels and Resorts.
For some reason, you have lighted upon this particular Four Seasons company as being the right Four Seasons company, and I'm curious to know what led you to that conclusion.
Yes, I'm getting there, my lord. It's a bit of a chain, but I will deal with that. I was going to deal with it in considerable detail, but let me try and deal with it within a very short compass. We write to Four Seasons Resorts and Hotels. We write to them at 1165 Leslie Street in Toronto. The person who responds is Miss Waugh. Miss Waugh describes herself as the legal corporate advisor. She uses that address. She uses the website. She uses the tree logo on her letter heading as well. We then do a dummy booking through Miss Kennedy. Miss Kennedy's, the literature that's generated from that, all uses Four Seasons Hotels and Resorts, or Four Seasons. It uses the same website address. It also directs all inquiries to one address, 1165 Leslie Street. 1165 Leslie Street is, according to the evidence of Mr. Donovan, the registered address of Four Seasons Holdings, Inc. It is also accepted by Mr. Newman in his witness statement that they were served at the registered address. There is no evidence from any other source, certainly not from the defendants, to suggest that there is any other company with that registered address, at that registered address.
You've looked for such
evidence. There is
evidence.
only one registered company at 1165 Leslie Street.
So it was essentially the website that led you to the address, was it?
It was also the correspondence from the legal advisor, of course.
Anyway, you've discovered that this is a Four Seasons company which is registered at the address from which the answer from Miss War came.
No, from which, because there's a legal notice as well. I need to take you to the legal
Yes, I've seen
notice.
that.
Do you wish me? Because that also directs it identifies.
Where is that?
Yes, that's in Appendix 2. Ms. Kennedy's witness statement starts at 355.
Try tab F.
Yes. Could I take you to the exhibits briefly, and it'll, if we go to 363, this is the account registration email. You can see it's...
I'm sorry, I don't think that's the MS number.
530.
It must be the appendix number.
530.
Thank you.
530.
My lady, yes.
63.
Tab A, does that...
I've got several of those.
This is an email to Claire Kennedy.
This is an email.
For reservation support.
Yes, reservations. Can I just very briefly take it? You can see the logo being used in the left-hand side. You can see it, they just refer to Four Seasons profile. Welcome to Four Seasons, there's no distinguishing between them. The website is fourseasons.com. Worldwide Reservations Office, what is it? 1165 Leslie Street. Four Seasons Hotels and Resorts, Worldwide Reservation Office.
Sorry, where do we find that?
It's in the bottom, very bottom of the document, my lord. 1165 Leslie Street.
Right.
Over the page, you've got the full address. It's the same postal code. We want your experience with Four Seasons to be a reassuring one. To contact the sender of this email, Four Seasons Hotels at that's obviously a typographical error, 1165 Leslie Street, because it's the same postal address. If you look at the postal address at the top of the page and the postal address at the bottom, they're identical, so it's obviously a typographical error.
So,
Carry on, my lord. The next document is a meet and greet. Won't help us very much.
Document at page 365.
Then we've got one, a reservation confirmation, very similar. This is done in September 2012, to the same effect, so nothing's changed in between time. You've got tours and excursions mentioned on that website as well. Door-to-door services mentioned there. And you will see Safari and Fayoum, which is the one which was a modified version of which the claimant agreed to, is on the last page. World of Four Seasons.
Sorry, last page is what page?
The last, mine is 379. What's yours?
379,
We don't have the
379, did you say?
371.
371, yeah.
That's, I hope my numbering's the same as yours.
That's excursions, yes.
So the last bit of D, tab D, if you're in the appendix bundle.
So on page 371, what should we be looking for?
Halfway down the right-hand.
Yes,
corner,
I
where it
see.
says Safari in Fayoum or
Fayoum.
Safari and Fayoum.
Fayoum, perhaps.
This off-road adventure.
Is there a reference to the Canadian entity?
No, it's
here?
just the world of Four Seasons,
Right.
and Four Seasons at the very bottom of that page.
I take it that
And then, yes.
the World Reservations Office which is referred to, for instance, on page 367 and on an earlier document that you referred to, that's not the number that Lady Brownlie claims to have rung. She rang the hotel in Cairo.
Because she'd stayed there the year before.
Yes, absolutely.
Lord, that is correct, yes. Then there's a later reservations one, but if I could take you on to the legal notice, which is behind tab F, probably 376, my lord. So this is the legal notices. There's a link to legal notices because if you go back to say 372, you can see legal notice, very top of the page, legal notice, privacy policy,
I see.
site map at
So you
Four
click
Seasons.
on that and you get page 376.
Yes. And then you get legal notices, Four Seasons again, and these materials are provided by Four Seasons Hotels Limited in Toronto. Now, what we'd say about
Its
that is,
subsidiaries, affiliates and related entities.
and its related entities, correct, as a service to its customers, etc., etc.
And the bracket Four Seasons in inverted commas
Relates to all of them,
relates presumably when subsequently used to all of them.
as the case may be.
Yeah.
Yes. And its customs, yes. And so, trademark notice, this website contains the Four Seasons tree device and other valuable trademarks owned by Four Seasons to distinguish its services and
I
wares.
also have the last sentence of the first paragraph is of some interest. If you do not
By
agree to
using
these
this site.
terms, please do not use this site. And you have to have good eyesight to read the term.
Or a computer that maximises.
Well, that's true as well. Yes.
So, and you've got on the right-hand side, just behind the trademark notice, for further information, please write to Four Seasons Hotels and Resorts, Legal Department, 1165 Leslie Street, Toronto, same address. A restricted license is referred to there. It's again referred to as Four Seasons. The general notice says also the website contains Four Seasons tree device and other valuable trademarks owned by Four Seasons to distinguish its services and wares. And so Four Seasons as an entity is not being specifically identified, we accept, but over the page is the tree logo. Check out our newest hotels. You can see how they describe themselves, Santa Fe, Baku, etc., etc.
This is a legal notice,
This is a legal
entirely
notice.
concerned, I understand it, with the protection of the intellectual property of one or more Four Seasons entities. Is that right?
My lord, that's right. That is right. But what it is providing is the link all the way back to 1165 Leslie Street. And if we go to the correspondence next with the legal advisor, you have to go to Mr. Donovan's witness statement and the letter of request, which is starts at tab 9.3, MS 343.
340, sorry, I didn't catch that number.
343, my lord.
This is the letter from Kingsley Napley to Leslie Street.
That's correct, on the 7th of June. And it's written to the 1165 Leslie Street address, and it's written to Four Seasons Hotels and Resorts, which of course is what's on all their literature. And then we go to page 178 internally, MS 345. Our request. 5, if you're not prepared to accept liability, please set out your reasons and identify any other parties you believe to be responsible. Please do also provide copies of the following by way of pre-action disclosure. B is documentation concerning the relationship between the hotel, the tour guide, internal investigations, payment records, etc. Now, it's that which Miss Wall studiously declines to answer. But so there's been a reminder, page 181, MS 348, on the 23rd of July. And then we get her answer. And you can see here, you've got the Four Seasons Hotels and Resorts and the tree logo, the valuable logo of the company. She's described as Marilyn Waugh LLB, corporate legal advisor. And we are in receipt. Please be advised, we have provided you early correspondence to the Four Seasons Hotel at Cairo, and we will follow up and request a timely response, which is never done. Now, the address on that is 1165 Leslie Street, with the same fourseasons.com address. And as I've said earlier, that is the registered office of the defendant, and the only company on the evidence that has a registered office at that address.
But I mean, all of that is consistent with the assertion in their evidence that essentially there are license agreements between various Four Seasons entities or hotels. It certainly suggests that the entity at 1265 Leslie Street is the owner of the intellectual property, which would be one of the most valuable items, one supposes, in the license. But it's not inconsistent with that, is it? It doesn't identify the licensee who operated the particular hotel.
Well, as Mr. Justice Tugendhat found, and rightly in our respectful submission, that he had no evidence from the defendants that related to the time in question when this lady was at the hotel. All of it was done, first of all, it was done illegitimately because it was non-compliant with the CPR, never gave the source of information, it never gave it in relation to the time that we're concerned with, which is the time that Lady Brownlie booked the tour in December 2009, or when she took it immediately after the start of 2010. And Mr. Justice Tugendhat, in our respectful submission, was quite right to say the defendants have adduced no evidence whatever to deal with the questions that they needed to deal with in this case, which was identity of the party that undoubtedly had a management relationship with the concierge who offered this for sale in their name, Four Seasons Hotel.
And the difficulty, or one of the difficulties, is that the burden of proof is on yourself. You could have made an application, could you not, for disclosure on this question.
But before issuing proceedings?
You could have made an application after issuing proceedings when you got these unsatisfactory answers. You could have asked the court to order disclosure in relation to the jurisdiction issue.
Well, my Lord, I hesitate because I'm trying to deal with this whilst I'm on my feet. I know there is statutory provision which allows this to be done in the case of personal injury claims.
Well,
There's
there
a
are
specific procedure.
wholly general provisions relating to the ordering of disclosure at any particular date. And there are cases, not many reported, but one example which was reported is Bank of Credit and Commerce International against Keilani, which is reported at 1999 ILPR. I'm not quite sure which version of which set of law reports that is, but I can let you know later. And I believe that there are other cases where the court has ordered disclosure in relation to a jurisdiction issue, notwithstanding that it was not a personal injury claim.
Well, perhaps my Lord will supply those details for everybody in court to consider overnight, which would be rather fairer to everybody than expecting you to deal with it on your feet. But you will no doubt deal with it in due course.
The all events your case is, I understand, fairly simple. There's clearly something called, there's some sort of trading entity called Four Seasons. The literature which we've seen gives an address. We found a company that's based there, and that's as much as we can be expected to do.
As much as we could be expected to do, and as much as we could do, because
We've therefore met the test of establishing a good arguable case with the better of the argument that we've got the right company.
we've got the right company, and so far, Mr. Justice Tugendhat, were fully endorsed by the court.
Page 379 is the back of page 378, is it?
379.
Well, it's only of some interest because this is said to be a reservation confirmation sent by Four Seasons, whoever they may be, and then it has on the back, which I assume is the back of the same document, a provision entitled Guaranteed Deposit and Cancellation Policies, and then Four Seasons Hotels and Resorts Worldwide Reservations Office. And so it may be, it could be said, that this was, on the face of it, an agreement with this entity at, wherever it is, at 1165, acting in their capacity as, quotes, a worldwide reservations office. And it might be said, what more do you want? Doesn't meet the case of when the contract was made, though, or where it was made, rather.
Well, the trouble is it's equally consistent with it being a reservation agent for the group, which is what one would expect.
Well, possibly.
Where do you want to go from here, Mr. Ross?
Well, just to confirm, if it needed confirmation, that this was tried twice, and you can see, if you're looking for another legal notice of a later date, the 21st of June 2013, you'll find that internal page 389. MS 389.
MS 389.
It's another one to the same effect, isn't it?
It's exactly. So nothing has changed in the intervening period.
No.
That's all. Whilst we have this file,
About tenses, I suppose.
whilst we have this file open, Mr. Labette made his witness statements at tab 2 of this bundle, starting at 391. You can see he has a visit to the hotel in January 2012. If I endeavour to summarise his and the ensuing documents, you can see throughout the hotel, everything that he has by way of contact with the hotel during that stay is emblazoned with the tree logo and Four Seasons Hotel.
Of course it is.
Now, am I right about, in this sort of case, is it important to how these tours are offered to members of the public, bearing in mind it's a consumer type contract? The answer is there are authorities, which I'd like to take the court to now, if I may. I think if we could start with the case of Wong. Volume 8, tab 79.
Page.
296.
Sorry?
296. Tab 79. So this is a case, a tour operator, as you can see from the head note, contracted with the plaintiff's daughter to provide a package tour to a lake in the People's Republic of China. First defendant's brochure contained the terms of the contract, described the itinerary for the tour, which included transportation across the lake by ferry. Down at H, the judge held the second and third defendants were liable in negligence. First defendants liable for breach of a contractual duty of the plaintiff's daughter to take reasonable care for her safety. Court of Appeal Hong Kong allowed the appeal to the Judicial Committee. They overturned that decision, allowing the appeal, having regard to the contract as a whole. The first defendant had undertaken thereby to provide the plaintiff with all the services included in the tour and the itinerary, not merely to arrange for their provision.
Well, that's on the content of the contract, isn't it?
It's correct.
Yeah.
Absolutely right, my Lord. B, a term was to be implied, and so on, rendering of services, and that since no measures had been taken to ensure the driver of the speedboat was reasonably competent, experienced crossing the lake, first defendant be liable for breach of contract. Now, if we go into the body of the judgment, page 41 of the judgment at H, the issue is thus whether in this particular contract the first defendant undertook no more than they would arrange for the services to be provided by others as their agents, or whether they themselves undertook to supply the services when, subject to any exemption clause, that there would be implied obligations. Of course, many contracts under which a person agrees to supply services when he may arrange for his obligations to be performed by others, where it's indeed contemplated that he will do so. Just below C, the fact that the supplier of services may, under the contract, arrange for some or all of them to be performed by others does not absolve him of his contractual obligations. That's all standard. And then there are two distinct categories of case at E, where the party agrees merely as an agent to supply, arrange for services to be provided, and secondly, where he undertakes to supply the services. Then they go on to deal with the case of Rogers over the page just above D, which is a Court of Appeal decision, and approve it. That was a taxi driver case. Lord Justice Dunn at G considered that whether the claim was put in contract or towards a primary duty owed to take reasonable care. Again, a difficult case. The court is entitled to find the obligation undertaken was one which be performed by another. The defendant remains liable for the performance of the services and skills. If we carry on, we get to the brochure at C on page 45. And at H, it was always clear the first intention that parts of the package be carried out by others, in particular in their respective spheres by the second and third defendants. That does not, however, conclude the question. It still has to be considered whether, one, the first defendant was in reality doing no more than arranging, so that they undertook no liability for the default of others in providing the goods and services, or two, at most a liability to take reasonable care. In the present case, there are terms in the brochure which are treated as part of the contractual arrangements. No clear statements from the first defendant.
This case,
doing no more than arranging.
This case shows why the line initially taken, that the responsibility was entirely that of the limousine company,
yes,
was a bad point,
yes,
which is common ground now. Does it go any further than that?
It's just the passage in relation to the terms, because they're indicating just below H on this same page. It must, however, be borne in mind that tour operator has the opportunity to protect himself. H on page 46.
46, okay, thank you.
Yes. It must, however, be borne in mind the tour operator has the opportunity to protect himself against claims made in respect to services, but by negotiating suitable contract terms with those who are to perform those services, may also provide insurance cover, may include appropriate exemption clauses, etc., etc. Now, and then they say at E, effectively, it's not intolerable to impose that sort of obligation on a tour operator.
Yeah.
So we have no exemption clauses here. We don't have any qualifications here in relation to this tour brochure. Your lordships have seen the brochure. It simply has the logo on it and the Four Seasons name. If we could go to Moran next, please, which brings it closer to home, and it's a case concerning logos. It's in volume 6. It's the first one in volume 6. This is a tour company. It's a motorcycle ride. Defendant tour operator acts as undisclosed agent for a local principal company that provided a quad bike excursion to the claimant holiday maker and as such liable to the principal. Now, if we go to paragraph 18, you can see the way in which this is approached. This is by Ms. Nicola Davis, QC, as she then was, now Mrs. Justice Davis. 18, it's agreed the claim does not arise out of the original package holiday contract. The contract for the provision of the quad bike was a separate and later transaction. The factual position pleaded by the defendant was that Dominican Quad Bikes was the operator of the excursion and the principal to the contract. Evidence of the claimant and her husband was that at all times they believed the contract was made with First Choice. In support of their belief, they relied on 3 matters: documentation provided by the defendant, manner in which earlier safari excursion was dealt with and performed, C, the fact that they could have bought a cheaper quad bike excursion but did not do so because of the defendant's guarantee of insurance from Mr. Moran. The relevant documentation comprises welcome pack booking form. Welcome pack had 2 logos at the head of this document, First Choice and Unijet. Booking form, the logos on the front of this form are First Choice, Barcelo and Outback. Towards the bottom of the page, there's no mention in this document of Dominican Quad Bike Adventure, although there's a logo of the booking agent of Barcelo. Over the page, it's unsurprising that provided with this documentation, the claimant and her husband believed that First Choice was supplying the excursion with the relevant safety checks. Receipt of booking and confirmation. I think I can go on to 21, which deals with the impression created by the defendant. Taking the defendant's case as its highest, namely the presence of Barcelo logo at the top of the document, I do not regard this as sufficient to displace the impression created by the defendant in its welcome pack and the front of the booking form that the excursion was supplied by First Choice. 22, the documentation supplied by the defendant left Mr. and Mrs. Moran with the justifiable impression that the excursion contract was being made with their tour operator, First Choice. Nowhere in the documents is there any reference to Dominican Quad Bike. And the presence of an unexplained Barcelo logo on the booking form takes the issue a little further. I'm satisfied in respect to the quad bike excursion, First Choice did not disclose that it was acting for its pleaded agent, namely Dominican. Even if I had doubts as to the evidence provided by the documentation, the unchallenged evidence of the claimant and her husband was that booking and performance of the safari excursion pointed to the defendant providing the excursion. Mr. Moran's belief that the defendant was the supplier of the excursion was the basis of their refusal to book a cheaper quad bike tour. And so
that's another case. That's another case, Mr. Ross, is it, where the identity of the tour operator is known, and so therefore you can go straight to the question of whether that entity, that company, held itself out as acting as principal, and so is liable even if there was an undisclosed principal behind them.
That's right.
But does it help us a lot in a case where it isn't clear who the tour operator is?
Well, it does help us if the court is satisfied that the impression that's being created by the provision of the brochure and the setting in which it's provided, namely in a Four Seasons hotel, indicates that it was Four Seasons that was providing
you can
attribute
the tour. As long as you can attribute it to the first defendants.
Well,
problem here is surely that Lady Brownlie didn't know anything about the entity in Canada. She simply knew about the hotel in Cairo, and she had received brochures from them. What identified the entity in Canada was your solicitor's subsequent researches.
But we respectfully submit that's neither here nor there, my lord, because what is important when you're looking at a consumer contract or consumer type contract such as this is the impression that the provider of the excursion is seeking to create. Now,
Do you say the impression that the provider of the excursion was seeking to create was that this was a contract with an entity, the particular contractual entity that you have sued, the first defendant incorporated in Canada?
I don't think I need to go that far, my lord, because what I need to establish is stage one, because there are two stages to this process in our respectful submission. The stage one is, what did she reasonably believe? She said so in her evidence. She believed it was an international company that ran hotels through the world. Now, it didn't matter to her where Four Seasons was based. It was the Four Seasons company that operated and managed hotels throughout the world. So that is the entity that she believed was the provider of this excursion tour.
But it's not an entity at all. That's the trouble. You see, the belief of the consumer is, as I understand it, absolutely irrelevant once the consumer is dealing with a known a known legal animal, and the legal animal makes some kind of representation that it's acting as a principal. That's easy. The problem is when you don't know who the legal animal is.
The legal animal is the legal animal who's holding itself out as trading as Four Seasons.
I see, and you say that's the Canadian company. Yeah.
Because the Worldwide Reservation Service was identified as being carried on in Toronto. Is that right?
But because it was an international company which had a base somewhere, and so stage two is the process of ascertaining which is the entity that's describing itself as the Four Seasons provider of this excursion service. So you don't have to descend to a level of particularity at this stage. Why? Because they choose not to do so. Got nothing to do with the recipient of it. It's Four Seasons that's creating this miasma. And deliberately so, it would seem now, with the wisdom of hindsight. Although presentationally, it's as simple as ABC. It is a Four Seasons company that runs all these hotels throughout the world. The question is, what is that Four Seasons hotel? We've done what we can after the event, given that there's no cooperation, to ascertain who that might be. The linkage is the logo, and the logo, all roads lead to 1165 Leslie Street. There's no other road, there's no other path.
Before these actual events,
Yes.
is there any evidence that the claimant knew anything about Canada or anything at all, really?
There is evidence as to what her belief was. It's in a witness statement.
Yeah.
And it's adverted to by Mr. Justice Tugendhat, who placed reliance upon it. She said...
Where should we be looking?
It's tab 17, and it starts at MS 434. Paragraph 4.
Sorry, I'm not there yet. Tab 17 in the core volume, this is?
Yes.
Right, okay, I'm there.
Paragraph 4, we chose the Four Seasons Hotel in Cairo because we'd stayed there before and because of the international reputation of the hotel group for its high standard of service. When we visited the year before, we planned to return, and so I picked up a booklet from the hotel which advertised the safari tours that the hotel provided. There was nothing in the booklet to suggest that the safari tours would in fact be provided by a third party. She's referring to the hotel as being the hotel which called itself Four Seasons.
She's
Which
talking
she
about...
believed, because if we go over the page, we've got the dealings with the receptionist, which I'll have to come back to when I deal with where the contract was made. And she deals with the events of the day in question. And then at paragraph 10, she's still saying there's nothing to distinguish the people who came to collect her as being different from the Four Seasons Hotel. 11, for us, this was all consistent with the tour being part of the 5-star services of being provided by that hotel. This is exactly what we wanted. When we travelled, we did not leave our legal brains behind us. We booked through the hotel because we wanted to deal with an international company with a very good reputation. So it's an international company with a very good reputation which ran Four Seasons hotels throughout the world. Now,
Is that a suitable moment?
Yeah, one final sentence, if I may.
I thought
That's
you've got
why
such a
when
good peroration there.
when we come back to Wong, Wong is a reminder that those who provide these services have the ability to put in their brochures whatever terms they like as to who is providing it, and they did not. There's no attempt to refine the identity of the provider of this excursion.
My lady, may I just ask a question? Your ladyship did mention this morning my taking instructions, which I'm going to try and do after court, as to my client's position as to disclosure of... I'm not quite sure what...
It was certainly mentioned in the course of
certainly
your argument.
I wasn't quite sure whether your ladyship had in mind, as it were, our case as to who was the other contracting party, or the organisation of different companies within the Four Seasons group, which was closer to the suggestion of my Lord Sumption's suggestion of an issue being
Well, the relevant part of the organisation, not the entirety of it.
Yes, not the entirety, but yeah.
Well, the obvious question of interest is who was running this hotel, to which
Yes.
your clients will know the answer. We were asking you what your instructions were as to whether or not to disclose them.
Yes. Well, I didn't have them, but I will...
But also it strikes me that your clients must have known who was the other party to this contract. And that's the critical question, to which we'd very much like to know the answer. At least I would.
Lords, that places me in a bit of a difficult, because I've no basis when this comes in tomorrow of knowing whether it's true or not. I mean, one of the points taken by Mr. Justice Tugendhat was that producing the witness statements in the way that they did, nobody can be held responsible for anything that's said in those witness statements that wasn't true. Because they've neither said that it relates to the period in question, neither have they identified the source
All
of
that may be true, but these are points we can address in any event.
Exactly.
Wait till you see the gift horse.
Yes,
Mr. Ross.
yes.
It may not be as bad as you're...
There may be no gift horse. There may be a gift. Whether or not it's a gift horse will be for you to explore or represent to us tomorrow.
And whether Mr. Farmer has instructions to identify them may well enable us to form a view about whether Mr. Justice Tugendhat was right to attribute unattractive motives to his clients.
Now is the moment at which to adjourn. We will hear from you further, 10:30 tomorrow morning.